ccmw.com/Edmonton. We welcome you to revisit the content yourself and share it with networks. Now, please ensure that your video camera and microphone are muted during the workshop. This will help eliminate ambient noises and increase clarity. We invite your comments and your questions, and we will run a few Q&A sessions throughout the workshop. Our lawyer very kindly has noted that he's happy to receive messages at any time as well, so feel free to interrupt if needed to ask any burning questions, but we will definitely have opportunities set out throughout the presentation to ask questions. There is a chat box that you can use, which might be the easiest way to use it to provide and note questions that you might have through the presentation. It's the 6th button on the left at the bottom of your screen. Once you click it, the chat box will appear on it will appear on the right-hand side of your screen. If you think of a question at any point, just type it into the chat box and it'll be posted for the Q&A portion. You can also choose to ask questions anonymously by sending a message to myself or to the host, who is Zainab. And you don't have to send it to everybody that way. That way you can just send it to one person and we'll address it later. An evaluation will be emailed to you later today. It'll take about 5 minutes or so to complete. You don't need to include your name on this form, so please don't. The intention is to maintain anonymity. The information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. If you require technology assistance, please send a direct message to myself using the chat box. The Canadian Council of Muslim Women, or CCMW, is a national nonprofit organization committed to attaining equality, equity, and empowerment of all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civil engagement, and empower communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal professional, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. We can move on to the next slide. Previously, CCMW published Muslim and Canadian family laws, a comparative primer in English and in French, and a series of booklets in several languages on family law topics to further its public's education efforts. Our latest project in this field, Muslim Women, Family Law and Legal Rights, is updating these documents and disseminating them via knowledge-sharing workshops within different cities across Canada for Muslim women, community service providers, and legal professionals in the general public. Can we move over? And this is an example of the family law brochures that I just mentioned. In 2003, CCMW took the lead in establishing a coalition against religious arbitration composed of over 50 sister organizations, including the National Association of Women and the Law, so that stands for NAWL, MRTRAC, and YMCA. The non-religious arbitration movement and the CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW advocated for one set of laws to be applied to all, regardless of faith, ethnicity, race, or culture, under the existing family law legislation. CCMW believed that the use of religious laws through private arbitration to settle family matters under the Arbitration Act violated the hard-won equity rights guaranteed under the Canadian Charter of Rights and Freedoms, and has the potential of creating a two-tiered, fractured justice system. CCMW was compelled to inform Muslim women about the choices they have available to them within the Muslim and Canadian family laws, and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, and 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, please visit www.ccmw.com. Disclaimer: the information contained in the webinar today is information. It is not legal advice and should not be interpreted as such. If you or someone you know is dealing with family law issues, it is important to meet with a lawyer to discuss the situation and to receive legal advice. The webinars, the brochures, and the primer are not a replacement for legal advice. I now have the opportunity of introducing our lawyer, Jamil Sawani. Jamil completed his Bachelor of Applied Science degree in Biomedical Engineering in 2004 from the University of Toronto, and went on to earn his Juris Doctor degree in law from the University of Alberta in 2010. Recently, Jamil received his Master's in International Corporate and Commercial Law this year from King's College London. Jamil was admitted to the bar and became a member of the Law Society of Alberta in 2011, and since then has been practicing criminal and civil litigation law with Chaddy & Company barristers and solicitors. During this time, he has acted as litigation counsel in a number of precedent-setting constitutional and civil rights cases. Jamil is also a qualified mediator and received his designation by the Alternative Dispute Resolution Institute for Alberta, and has been providing pro bono family and commercial mediation within Muslim contexts as a board member of the Aga Khan Conciliation Arbitration Board since 2012. And now I will be handing it over to Jamil Sawani. Thank you very much for running the sessions for us today. We're very much looking forward to it.
Bismillahirrahmanirrahim. Assalamu alaikum to all of you, and thank you for being on for this webinar. I'm hoping that we can have a very interactive session today in which we discuss some of the complexities of both the Canadian law with respect to family law and how it interacts with members of the Muslim community in particular who may come from different backgrounds and may have different ideas. And maybe dispel some of the misconceptions of how and when Canadian law applies within the family context. So the goals for today are to essentially assist Canadian Muslim women and more generally the stakeholders within the communities, the civil society apparatus within Muslim communities to make informed choices in the area of family law in Canada, and assist professionals, students, other institutions in learning a little bit more about the comparison between Canadian and Muslim family law across a few different scenarios, essentially marriage. We'll be talking today about marriage, divorce, custody and child support, a little bit about family, property and spousal support, and domestic contracts and inheritance. So as noted in the disclaimer before, I'm not going to be providing legal advice in this particular session. I'm going to try to speak at a very high level in terms of some of the misconceptions, but ultimately, and I must reiterate, if there's any particular legal question or anyone is currently facing a matter that needs some legal advice, that each individual or institution should seek out that legal advice from a qualified lawyer in your area. I understand most of the individuals on this call are from Alberta, so I'll be focusing most of my scenarios and how the law works in the Alberta context, but I'll speak about some of the differences in the regions as well. So I think the next slide is just the agenda for today. The beginning of the presentation, I just want to spend a little bit of time to talk about this concept of Sharia and also law based on the Sharia and exactly what that is. It's come to take a large part of the imagination of individuals both within the Muslim community, outside of the Muslim community, and maybe just get to the clear definition of what we're talking about when we're talking about Muslim-based family law. And then also go on to talk about essentially what Canadian law is and its applicability within these contexts, within the family law context for Muslims in Canada. And then actually get into the nitty-gritty of some particular scenarios. We're going to be getting into a scenario with a particular couple and family. There will be opportunities to see how this family progresses in terms of different issues that come into their lives with respect to their marital life, and discuss those issues that I spoke about before, things such as divorce, marriage, inheritance, child support, custody, things of that nature. So there will be a lot of opportunity, as Tamizan so kindly explained earlier, to have discussions in regards to specific questions. But if at any point in time anyone has any burning questions or something that's pertinent to what I'm speaking to at the time or at the moment, feel free to put it into the chat, and Tamizan will interrupt me at some point in time, and I can address those questions. As well as maybe ask whoever is asking those questions to maybe clarify if I don't understand where they're coming from. We're a pretty small group for the moment. Hopefully more people will join, but that also means that we can have a more intimate discussion as well. And I'm looking forward to that. So as I noted earlier, I'd like to start by addressing this whole issue of what it means and what we mean by Muslim family law or Sharia and the application of Sharia. And oftentimes we don't have a sense of definitions in terms of what we're talking about when we speak of Sharia. And one major confusion is there is a conflation of two ideas, which is Sharia, which is essentially an ideal that Muslims seek to approach. It's a way in which we hope or a path towards living in a way that's in congruence with the will of God, essentially, living in an ordered community. That is always the goal, ultimate goal. Now, the question of how we achieve that is the application of essentially man-made systems of thought to come to rulings and laws that hope to approximate what the Sharia would wish of us. So the Sharia is a goal. When we talk about the law, though, oftentimes what we're talking about is a word called fiqh. Fiqh essentially is a form of judicial knowledge that is approached or is come to through different communities within the Muslim ummah, within the plurality of what is the Muslim communities around the world. They use different means of coming to these laws or this fiqh that seeks to implement the goals or the ideals of Sharia. Now, when I say man-made rulings, oftentimes, and for the majority of the history of not only Muslim law, but law at large within all communities, it has been just that, man-made, in the sense that very few female voices have gone into the creation of these rulings or these bodies of law. And that, of course, comes across in the way in which fiqh has been formulated, both traditionally and in the present as well, although things are changing in that regard. Fiqh is a continuing process. Sharia is the ideal that is essentially something that is static, but never can be truly approached. It's always an effort. So. So now the question is, how do Muslim communities come to what this idea of fiqh, or the laws that seek to approach Sharia? In that regard, there are different schools of thought within Islam, and I do have to spend just a little bit of time talking about the diversity and the plurality, and that there is no one brush with which we can paint every single Muslim community or even individual within those Muslim communities when it comes to their conceptions of what Sharia, what that ideal is, and also what law is based on that particular ideal. But fundamentally, almost every single community would look towards ultimately the Quran, as well as the life of the Prophet and the principles displayed in the life of the Prophet, which we call the Sunnah, as a fundamental source from which we derive principles of Sharia, as well as the laws based on such principles. And of course, there are two major branches within the Muslim faiths and Muslim communities, and those would be the Sunni as well as the Shia traditions. Generally, within the Sunni tradition, the other sources of law include the idea of consensus of the community, analogical reasoning, and these are legitimate sources from which these legal rulings or laws traditionally have arisen. And even within the Sunni community, there's much diversity. There are different schools of thought. There are four major schools of fiqh, or four major schools of law. And even within those schools, there's diversity of opinions as well in terms of different ways of applying these principles to reach a final conclusion in terms of how we should live our lives and what laws should apply. Within the Shia traditions, there's further pronouncements of the imams, or the Shia imams are also considered authoritative and also provide guidance in terms of how the law or the fiqh should be formulated. The Shia traditions, in addition to the Sunni traditions of the Maliki, Shafi, Hanbali, and such, the Shia traditions include the Jafri tradition, as well as different traditions based on the different movements within Shia Islam that give rise to these different and varying conceptions of what Muslim law should be or should look like even in the contemporary time. So it becomes a little bit difficult for us to talk about one form of Sharia law, but there are general principles and general consensuses across the broad spectrum of the Muslim community when it comes to certain aspects. As I noted earlier, there's a significant role of interpretation in developing Muslim law or fiqh from any particular ideals of Sharia. Basically, within each Muslim community, regardless of the school of thought, it's not something that is created in the moment. It is something that has been developed over many centuries, often in terms of principles and ideas that somewhat are akin to the idea of common law. In fact, within the common law jurisdictions, or even Canadian law, this idea of precedent, this idea of following general principles. So it's something that is a very well developed set of laws, but of course they all have different flavors and varieties because of the fact that they all have their own historical trajectories. When it comes to the directions of the Quran, often the Quran does have some verses that speak about rules of family law, but the majority of the laws that would apply to the realm of families, in fact, come from the man-made fiqh that I'm speaking about. This tradition of scholars not only applying the rules that come from the Quran because they need interpretation, but also applying things such as consensus, such as analogical reasoning, and other interpretations of history to come to certain rules that should be applied within a certain school of thought. And one fact that arises from this large plurality of different ways in which Muslims have conceived of the ideal of Sharia, as well as how it should be applied in terms of law, means that the Muslim community believes that there's no central authority with the right to formulate legal and ethical doctrines for everyone else. Many of the Muslim majority countries, in fact, have what we would call pluralist legal systems, in which you can choose which legal authority you want to ascribe to, which school of fiqh you would like to ascribe to, and therefore be ruled in accordance with that particular school. And that also means, when it comes to Muslim women in particular, they're under no obligation to follow a particular legal opinion of any particular school of law, let alone any specific jurists in matters pertaining to family law. When it comes to Canada, even as a Muslim, if you wish to be governed by a specific Muslim school of there is no overarching authority that will, in fact, impose that particular law upon you or upon a party that you wish that law to be imposed upon. There's no mechanism for that in majority of Western nations. It is a little bit different when it comes to Muslim majority countries, and I can talk about that if there are questions about that at a later point in time. And I think that brings us to Canadian laws. And what, as I said, there are different sources for the idea of Muslim law. In that case, there's general principles, there's the Quran, there's Sunnah, there's consensus, analogical reasoning. Canadian laws also have certain foundational sources. And those sources come from general principles, come from consensus and democracy, of course, but there are also some fundamental documents and ideas that form a part of the Canadian law. And one of them, the primary rule or guiding overarching rubric under which most Canadian laws proceed in the current time, is the Canadian Charter of Rights and Freedoms. And what that does guarantee, in addition to the rights to religious freedom and things of that nature, it does require an equality before the law when it comes to such characteristics as gender. Which means that the law is completely blind to gender, or the ideal is that it should be completely blind to gender, and the rights of both men and women are completely equal under the law. Canada is also a signatory to a number of international treaties that also re-emphasize that idea of equality under the law, such as the Convention on the Elimination of All Forms of Discrimination Against Women, the International Covenant on Civil and Political Rights, also address these international treaties which speak about the requirement of entrenching equality within the laws of a nation. This idea of equality, although it states that the idea of these documents trump the right to religious freedom, it's not as simple as that. Oftentimes, and there have been in past times when the courts have had to measure and weigh different rights, the right to equality versus the right to religious freedom. And sometimes there has to be give and take with respect to both of those. And that's something that our courts have had to juggle for quite some time. Canadian law, as I noted within when I was speaking about the idea of fiqh as well, is based on this idea of common law or case law, where past court decisions do actually create general principles and also shape the way in which the law gets applied in the future. So the source of Canadian law is, of course, the documents I've spoken about, written laws that are passed by the government, but also the decisions of past judges that address issues of family law, women's rights, things of that nature. In Canada, we also have an interesting situation where we're a federation, which means that the federal government or the national government has certain rights, whereas other matters are taken care of by the provinces or the territories. In general, family matters are split between some federal jurisdiction and some provincial jurisdiction. Things such as divorce and marriage, and the rules around divorce and marriage are regulated federally under the Divorce Act. So that's our national government, our federal government takes care of the rules around that. Whereas the rules around personal property, custody, access, child support, and things of that nature fall under the jurisdiction of the province. So we're dealing with different sets of laws when it comes to property, especially across the country. So the rules with respect to inheritance or even things such as meher, which I'll be talking about later, do vary drastically when whether you live in Ontario or in Alberta, because provincial law covers those type of issues. Also, inheritance is a matter for provincial regulation. So I've spoken a lot. I'm just going to take a little bit of a break. If there's any questions within the chat, or if anyone has any questions as to what I've spoken about so far, please feel free to put something into the chat. Otherwise, I'll continue.
Nothing so far, John.
All right. Now, one of the primary issues when it comes to law and the application of the law, and that is equivalent, whether we're talking about Muslim law or Canadian law, the law is of no use if you don't have access to it and you can't get justice. Ultimately, within the Canadian context, there is an issue of access to justice. Oftentimes, taking your issues to the courts can be costly. It requires lawyers, individuals like myself, who, although many lawyers try to give back to communities and do some pro bono work, that it's not feasible that everyone can get free legal services. And legal aid is something that the government provides, but often individuals don't meet the requirements to get legal aid, depending on the nature of the dispute. And people vary in terms of their eligibility. And in some parts of the country, victims of domestic violence are given priority, and things of that nature. There's a lot of different moving parts, and access to justice is a significant issue. And I'll speak about some ways in which those issues are being addressed. But one of the important things about access to justice is individuals knowing exactly what their legal rights are, what their legal options are at the very fundamental level. And that's what this particular webinar is geared towards, is giving a little bit of a primer in terms of what fundamental rights and laws are when it comes to family law in the Canadian context, regardless of your faith background, and also in context with particular issues that arise within Muslim families. When it comes to access to justice, I will, if I don't mention this later, in addition to legal aid, there are free services that everyone can be eligible to in terms of family law information clinics. In Alberta, I know they have them in Ontario as well, where you can attend court and free of charge, people will assist you with legal problems and at least help you fill out forms and things of that nature. But oftentimes when it becomes a very highly litigated matter, very contentious, complex issues, it can be costly, and that can be prohibitive for individuals even seeking out access to justice and access to the courts. So I think now we're going to be looking at a scenario Now, I know there's a long disclaimer here. I think Zainab is going to be from CCMW is going to be helping with showing the scenario. Zainab, you can feel free to read out the disclaimer as well and show the video, and you can get into some scenarios after that.
Perfect. Just give me a second and I will play that.
Yusuf and Aisha were married in Malaysia in 2002. Their marriage was arranged and they did not know each other very well. They were married in an Islamic ceremony and agreed on a meher amount of $10,000, with $5,000 to be paid immediately and the remainder deferred. The couple's first daughter, Maha, was born in Malaysia. They moved to Canada when she was 2 years old. Since then, they have lived in Quebec and Alberta. They moved to Ontario in July 2018. Their other 2 children were born in Canada, their son Rehan and their youngest daughter Hannah. Their marriage has been very difficult since they moved to the country. Yusuf does not understand or accept the rights that women in Canada have, and Aisha would like more independence and freedom. Yusuf makes good money working as an engineer. Aisha has been at home with the kids, but would like to go to work, now that their children are in school full-time. Yusuf does not want Aisha to work and has become even more controlling of her. They live in a house that is registered in his name alone, and all the bank accounts are in just his name. He provides Aisha with a monthly allowance. While Aisha is the primary parent of the household, Yusuf is the disciplinarian, and he can be quite strict. He uses corporal punishment with the children, which Aisha does not agree with. There are also many tensions between Aisha and Yusuf about their 15-year-old daughter Maha. She wants to go out with her friends and go to parties, but her father will not permit this. He also wants Maha to dress more modestly, but she wants to dress just like her friends. Yusuf recently returned from a trip to visit his family in Malaysia. He told Aisha he married another woman while he was there and that she will be coming to live with them shortly. Aisha is very shocked and concerned about what this will do to her status as Yusuf's first wife. Since getting home, Yusuf has talked repeatedly about taking Maha to Malaysia to marry his cousin's son. He says this would be very good for the financial situations of both families. Also, if Maha were married and living in Malaysia, they would not have to worry about her getting into trouble with boys here in Canada. Aisha is opposed to this and is thinking about leaving Yusuf to protect her daughter. But she wants to know what her rights and responsibilities would be, and whether she would have enough money to support herself and the children. One day, Aisha receives the shocking news that Yusuf has suddenly died at work. Neither Yusuf nor Aisha has a will. Aisha knows very little about the family's financial situation. She knows there's a lot of jewelry in a safe in Yusuf's home office, but she does not know the combination to get into it. She doesn't know where they bank, how much money is in their accounts, or how much money they owe on the house. Yusuf mentioned a few years ago that he inherited several $100,000 when his father died, but Aisha does not know what he's done with this money.
All right. Thank you, Zainab, for sharing that video. I think I'll just read out this disclaimer. Essentially, that scenario script and the scenario video. The scenario video are owned by the CCMW and cannot be recorded, reproduced, or distributed. Scenario is completely fictional with the sole purpose of anchoring participants in interactive discussions to engage in the workshop materials. CCMW is vigilant of racial, gender, and religious stereotypes used against and within Muslim communities, and strictly disallows the scenario script and video to be used to perpetuate the very stereotypes we strive against. For this reason, both the scenario script and the scenario video are prohibited from being accessed beyond the scope of this workshop. So if we can just go to the next slide. This slide basically has a breakdown of the first part of the scenario that we just viewed. What I'd like to do is leave that with all of you for just a good 3 or 4 minutes for you to take a look at, mull over, think about maybe some of the issues that might arise from this fact scenario, and then we'll go into some particular questions. Hopefully, after a little bit of a break, maybe if any of you had to take a short 4 or 5 minute break, we come back and hopefully you're ready to go with some answers to some questions that I might pose, and maybe we can have more of a interactive dialogue at that point in time. Or if we're good to basically carry on through without a break, I'm fine with that as well.
Why don't we take a 5-minute break? That'll give everybody a chance to, do a quick bathroom break if needed, and also just to read sort of this background. I agree with you, Jamil. It's 11:45 Mountain Standard Time, so why don't we reconvene in 5 minutes and then move forward?
Sure.
Wonderful. Okay, see you guys at 11:50.
Welcome back, everyone. Hopefully everyone's refreshed. We're now going to be doing a deep dive into Yusuf and Aisha. Now, some of the questions that arise off the bat is this idea of their marriage and and potential divorce. So the first question is Yusuf and Aisha's marriage legal in Canada? Now, I want to make this really interactive. Hopefully, feel free to just answer a yes or no to these questions in the chat. And hopefully we can start a discussion and maybe discuss some of the reasons why we might think yes, some of the reasons why we might say no.
Feel free to share your answers with me, and I can give a tally of what it is that I see, or feel free to share it with Jamil himself or with the whole group.
All right, so we have one yes. Do we have any contrarians here? So if they were legally married in Malaysia, then yes. So looks like the consensus is that yes, their marriage is legal. So there's two aspects to this. Yes, there's a question of if they were legally married in Malaysia, there's two ideas of what makes a marriage legal. And one is the formal aspect of it, which is did they go through with the procedure that you have to in the country that you got married? Was it a legal marriage in Malaysia? There's also a more fundamental question as to whether or not the marriage would be considered a marriage in Canada. So if, for example, this was Aisha at an age at which she could even get married in Malaysia. If she was, let's say, underage and it wouldn't be considered a legal marriage in Canada, that would be an issue that could potentially make it not a legal marriage in Canada. There's other aspects if there wasn't consent from Aisha, for example, if she wasn't able to consent to the marriage. There are certain things that could make it not legal, but for the most part, if they were legally married in Malaysia, then yes, it would be considered a legal marriage in Canada. And you don't have to do anything further. You could get it formally recognized by the registrar in Canada and get an order to that effect in Canada, but you don't have to. It is a legal marriage if it is, for the most part, if it's legal in the country that you got married. So the second question is, would Maha be able to get married legally in Canada? So this is their daughter, 15-year-old Maha. Would she be able to get married legally in Canada? So we have one response of a no. Most people are saying no. So that is, and not at 15, yes. So in Canada, in order to be able to legally get married, you must be above the age of 18. 18 is the age at which you can, of your own volition, get married. There is an exception for being able to get married between the ages of 16 and 18 if you have consent of both parents or the parents of the individual who's under 18. But 15 is absolutely below the age of consent, and there is no legal means of getting married at that age in Canada. All right, so you guys are 2 for 2, which is great. Let's go for number 3. If Aisha wanted a divorce, could she apply for one? We have a yes. Another yes. All right. Basically, everyone's saying yes. You guys are legal experts already. I guess maybe you guys should be giving this webinar, but for sure, Aisha can get a divorce if she wants one. Ultimately, there's no bar for her to seeking a divorce if it was, in fact, a legal marriage in Canada, of course. In that case, if she wants a divorce, she can apply for one, and there's no authority that she has to go to in order to seek that. She can do that of her own volition. Now the question is, where would she apply, and what reasons would she have to provide? Does she have to provide a reason to have to get divorced? I'll wait to see some responses. And if she does, what reason would that be? Irreconcilable differences, polygamy. She can apply to the courts and requires no reason. So it seems like we have a ringer in here. CCMW staff is saying could apply to the courts, requires no reason. Polygamy, irreconcilable differences. So in the province of residence, yes. So yes, that's one of the issues. Where would she apply? She would apply to the courts in the province of residence. Ultimately, you have to have been living within the province for a year. And that's also goes to the earlier question of if Aisha wanted a divorce, could she apply for one? Within the question, it's already clear that they have been living in Canada for some time. So yes, they could apply. She could apply for a divorce. And where would she apply? In the province of residence. What reason does she have to give? In Canada, there is a system of no-fault divorce. You do not have to provide a reason whatsoever. There is no bar to getting divorced. Irreconcilable differences is another word for we just don't get along, essentially. Polygamy could be given as a reason, yes, but you don't need to give a reason whatsoever. There is a cooling off period. It requires you to be living separate and apart for 1 year prior to being granted a divorce. But you don't need any particular reason to get a divorce other than the fact that you want one. In the cases of significant domestic abuse or violence, there are circumstances in which even that cooling off period of a year can be shortened to a certain extent, and you don't have to even wait that long. But oftentimes to even get to that process and get that issue into court, if it is an issue, often takes longer than a year in any case. So that's really not a bar and is not a reason that's needed in order to get divorced whatsoever. So I think you guys are really good at this already. Let's see if we can move on to the next scenario and answer a few more questions. So we saw that we got new information in the scenario in the video that Yusuf recently returned from a trip to his visit to his family in Malaysia, and he told Aisha that he married another woman while he was there, and that she will be coming to live with them shortly. Of course, Aisha is very upset and concerned about this and what it will do to her status as Yusuf's first wife. So now let's get into a little bit more interesting questions. So there's, before I move on, Tahira asked the question, does it make a difference whether there's a reason or not? Does it impact support or custody? As I indicated, there's a no-fault divorce system within Canada, and therefore you don't need a reason whatsoever. It doesn't make a difference ultimately, except for potentially shortening that 1 year period before you are granted your divorce. Does it impact support or custody? It doesn't in the general sense of things, except when it comes to potentially domestic violence, things of that nature. When you're looking at support in custody, the court looks at things in a holistic nature, and especially when it comes to custody and access, and we'll talk about that a little bit later. In terms of the best interest of the child, but the reason can seep in into those issues, but I think we'll address that pretty shortly as well when we get to those particular aspects of the scenario. So let's go to the polygamy questions, which I think are interesting, and let's see if you guys are still going to be 2 for 2 on these. So is polygamy legal in Canada? All right. So we have a general consensus of no, and that is correct. So you guys are up on Canadian law in that regard. Polygamy is not legal in Canada. It is actually an offense under the criminal code. With respect to this particular issue, it's gone all the way up to the Supreme Court even recently, and the law has been upheld that polygamy is not legal in Canada due to the concerns about the power imbalances that are created when such relationships exist, and the potential for abuse. So with respect to the second question now, would Aisha lose any of her rights because Yusuf has married another woman when he was in Malaysia? So we have one private answer saying no. All right, I have another no. Okay, so no, as she is the first wife, legally married. So this question is actually a lot more complicated than the first one. And part of the reason for that is we have to take a look at it from the perspective of all the individuals in this particular scenario. Of course, Aisha is the first wife. Now, Yusuf has married another woman. I don't know, and we don't know in this scenario whether or not she even knew that Yusuf was already married. It may be the case that she did not know, but regardless, if, let's say, she then does make her way to Canada, let's say, and does, form a life and a residence here with Yusuf, Aisha doesn't necessarily lose any of her rights, but that particular relationship may affect what she is entitled to in terms of collecting in regards to her rights, ultimately, if the marriage were to dissolve. And that is because, essentially, Yusuf could form what is somewhat akin to a common law relationship or an adult interdependent partnership, as it's called in Alberta, with this other woman, with his second wife from Malaysia, although that wouldn't be considered a legal marriage in Canada. But that individual may be considered as a dependent because the second wife would still be dependent upon Yusuf. So upon the dissolution of marriage, if there was a house, for example, that Yusuf maintained with this other woman, and she contributed to that house, looked after it, potentially even contributed money to it. In the case of having children with that other wife, it does make things very complicated. Child support now would be would have to be going to all the children that Yusuf has fathered, not necessarily only to the children that he has with Aisha. So it's not as cut and dry. She doesn't lose any of her rights, but the ultimate responsibilities of Yusuf do get spread thinner and thinner. So it does have technically an effect on her. And this is an area of law that makes things very complex when you have both a legal spouse as well as an adult interdependent partner. And the law is by no means settled in terms of how the court addresses these things, because it's an ongoing issue. And unfortunately, there have been scenarios, and I'm familiar with scenarios where oftentimes the second wife has no clue that she is even the second wife. So there's also issues of equity. So in the common law system, there are benefits that are given to this second wife often, and that does cut into the potential benefits that Aisha or support that Aisha could potentially get if this second wife wasn't in the picture. Are there any questions about that at this point in time, or we can continue, or does that give rise to any issues in your mind? Feel free if anyone even wants to unmute at this point in time and just has a burning question. I'm more than happy to take it. I'll give maybe 5-10 seconds. If not, we'll move on. All right. Someone noted it's a complex and interesting issue. It is complex and interesting, but it's also often very trying for the individuals who are a part of it, it's very difficult to be a part of that type of an issue as well. Oftentimes there's access to justice issues that are also a part of that in terms of individuals not really having recourse or knowing even how to access their rights or get justice in those circumstances. But there are some avenues, hopefully, that I can talk about later. Now we can move to child custody and child support. We have some new information since getting home. Yusuf has talked repeatedly about taking Maha to Malaysia to marry the son of his cousin. He says that this would be very good for the financial situation of both families. As well, if Maha were married and living in Malaysia, they would not have to worry about her getting into trouble with boys in Canada. Aisha is opposed to this, is thinking about leaving Yusuf to protect Maha, but she wants to know what her rights and responsibilities would be and whether she would have enough money to support herself and the children. Now, the first question is, under Canadian family law, how would a court decide who should get custody? Now, before we get into the question of custody, I think that's a word that's not really understood. In law, custody means something very different from what people usually think. In family law in Canada, there's two concepts: custody and access. Custody is the right to make decisions for the child. For example, where they go to school, what religion they will be brought up in, where they will be living even. Things of the nature of also whether or not they get certain medical procedures done. Having the ability to give consent to movement and things of that nature. So custody is different from access, which is being able to access the child and having time with the child. And oftentimes we think of them as being interrelated. So access is who gets to see the child and who does the child stay with and for what duration. And that's a separate question from custody. Custody is who gets to make decisions about her. So under Canadian family law, how would a court decide who should get custody in this particular case? We'll give people some time to think about it. So one response is best interest of the child. consideration of the voice of the child, who is 15. All right. That was I received that privately. All right. Well, the response of best interest of the child. That's very it's a very large concept, and that is the concept essentially that the courts in Canada use to decide. They look at the child and try to see what is in that child's best interest when it comes to custody. In this particular circumstance, when we're talking about Aisha and her concerns about her husband taking Maha, who's essentially been in Canada since the age of 2, grown up in Canada, has Canadian values, wants to do things that her friends are doing here. The concept or the idea of taking her to a different country and getting her married at the age of 15. Of course, Aisha has a very good argument that she should be able to make those type of decisions for Maha over and above Yusuf. That doesn't mean that she may get complete custody. There's other things that go into consideration. When it comes to even access to the child, there's a general principle within Canadian law that the maximal amount of time with both parents is something that is generally in the best interest of the child, absent things such as abuse, psychological abuse, or domestic violence, things of that nature. So there's a lot of different considerations that the court has. But ultimately, in this scenario, if I were to be a betting man, which of course I'm not, you would think that the court would consider the situation in terms of if it's proven that that's what Yusuf wants to do, that potentially custody would be primarily with Aisha, given that circumstance. But at the end of the day, it is the best interest of the child test. And yes, there is a consideration of what Maha wants as well. Since she's over the age of 12, the court has the ability to actually listen to exactly what Maha wishes to happen as well. She doesn't have the final say. She's still a minor. She's still a child, and at the end of the day, custody would be given or partitioned between the parents in the way that the court deems appropriate. So now the second question is, what would Aisha be able to do if Yusuf took Maha to Malaysia without her consent? Before we get to that question, I did receive another private message about sometimes a lawyer is assigned for the child. And often that is how the voice of the child is in fact heard by the court. A lawyer is appointed, a public guardian lawyer is appointed for the child, essentially, to allow the child's wishes to be expressed. There are other means of doing that as well. There's different, in Alberta, there's different psychologists that often children are sent to, and reports can be given to the court as well, in which the concerns and maybe some of the issues that the children are facing come before the court. But it is possible for the child themselves to even have a lawyer and be represented during these type of issues when they come before the court. So we'll go to now a very the very next salacious question here is, what do we do? No, number 2 is, what would Aisha be able to do if Yusuf took Maha to Malaysia without her consent? So now this has become an international issue. What can Aisha do in that circumstances? Feel free to enter in the chat, or if someone has any ideas, they can even unmute and speak to it.
I think we have to check out. This is Nassim. We have
Yes.
to check out if there is any international treaty signed with Malaysia, between Canada and Malaysia, and if we were able to get the child back to Canada.
All right. Yeah, no, that's that's important. I'll speak to that in a moment. There's also in the chat we hear charge him with kidnapping. Maybe hire someone at an international law firm with an office in Malaysia to assist. There's a combination of things. In fact, all of those are technically responses. But now the question is, what will she be able to do ultimately through all those avenues? So let's take a look at this. It's a very complex issue, and unfortunately, it happens often. The first thing that Aisha could do is try to stop the ability of Yusuf to leave with Maha in the first place. And that would be to get a order ultimately from the court that would block Yusuf from leaving the country with Maha. Often you can apply for that in court. It's a family law application. You can ensure that any passports that Maha may have or things of that nature are either deposited with the court or handed over to Aisha. The inability to apply for another passport, also things of that nature. If that isn't done in the at the outset, however, and Yusuf's already gone, the issue that we have is we have to then turn to things such as the Hague Convention for child abduction, as noted by in the chat by CCMW staff, by Zainab, or as Nassim had noted, there is a question of these international treaties. And there are some countries in which, for example, if Aisha got an order to have Maha returned from a court in Canada, you could take that order and have it filed pursuant to the treaty in a third country, in another country that is a party to this convention, and they would actually follow that particular order of the Canadian court and make sure that the child is returned. The police in that state would get involved and, in fact, so implement that particular order. The issue that we have with Malaysia is that Malaysia is not a signatory to the Hague Convention, so that particular treaty wouldn't apply. There are many Muslim countries that have signed that convention. For example, Turkey. If Yusuf had taken Maha to Turkey, if then Aisha got a court order within her own province to have Maha returned, then that order could be filed by a lawyer in Turkey to have that order implemented. And the Turkish police would then try to track down Maha and have her flown back to Canada. But that's not going to happen in Malaysia. Malaysia is not a signatory. Recourses that she may have then is to go to court in Malaysia or hire a lawyer in Malaysia and try to regain custody and access of Maha through the Malaysian courts. It's not a ideal scenario in any way, and it can take a long period of time, and there's no guarantee that she would be able to return. So this becomes a very significant issue when the country is not a signatory to the convention, and there are many Muslim countries that are not. Some are, but more often than not, it's not the case that you can rely on those type of international treaties. So oftentimes the best course of action is, if you feel that is a concern at the outset, is to get those orders in place. One would hope that if an individual came to the airport with a child who's a minor with only one of the parents, that the border control or the individuals at the ticketing counter would like to see that you have permission from the other parent. But oftentimes it's not caught. So it's a very leaky system in that regard. So prevention is the best course of action in this particular case. If there's any further questions about this or any issues that arise in people's minds around this issue, I'm happy to take those right now as well. I will note that this idea of criminal charges, ultimately, criminal charges can be laid in this regard against Yusuf, but if he's in Malaysia, of course, there's difficulty with those criminal charges ultimately having an effect. But it may be enough to convince Yusuf or his family if Yusuf has the intention to return to Canada at any time. That would be an issue for him. And it may be a means of bargaining potentially with Yusuf or his family, essentially to bring Maha back so that it doesn't proceed to a criminal proceeding, or he won't be apprehended by border security when he comes back into the country. With respect to repatriation or extradition, it really depends on the country. And Malaysia, it's unlikely that he would be able to be extradited from there. All right, we can go to the next slide if there aren't any other questions in that regard, and get to the issue of property. If we were to assume that there was a separation and a divorce, under Canadian family law, who would get the house? The parent that gets the children, mother, as she's caring for the two children, the spouse. So we have a few different answers. Don't they have to split it? And there's a question about inheritance if there's no will. But in this case, we're talking about the divorce. If they were to get divorced, who would get the house? In Canada, the house in this case, it would be their matrimonial property, according to the fact scenario that we have. It's the house in which they're living as a married couple. And pursuant to Canadian family law, and this would be provincial law, in fact, and this is pretty much the same across the board, across all the provinces, that the matrimonial home is jointly owned property at the end of the day by both spouses. So the question of who would get the house, they both get the house ultimately. Now, there may be a question as to who gets to stay in the house. It may be that the courts may give exclusive possession to one parent over the other. If, let's say, Aisha wishes to stay in the house because the two children are there, they're used to that particular house, then she may get exclusive possession, but that doesn't mean that she owns the house. And in fact, Yusuf may be able to get some compensation for the fact that he's not living in the house. So ultimately, of course, if the house were to be sold, then the property or the value of the property would be split amongst both parents, amongst both spouses. It may be that there is certain money owed to Aisha by Yusuf for child support, let's say, or spousal support, and after offsetting those particular obligations, she may be able to keep the house outright. But that is a question of ultimately how much property they have, how much money Yusuf is earning, what savings they may have, and how that gets apportioned between them. But generally, within the Canadian context, if you are getting divorced from your spouse, all matrimonial property, all property that is accrued during the time of your marriage, gets split 50-50. Of course, this gets a little bit more complicated with the idea of the second wife. If she is in the picture, and she is in Canada, and Yusuf has created a household with this other individual, and if she has children, it gets a lot more complicated. So it's not necessarily that every single piece of property is going to be split 50-50 in that case. And that's why it's very important in terms of designating, is this the matrimonial home, and also figuring out what portion may be contributed by the second spouse, even when it comes to other property. But ultimately, yes, the house, both of them get it. One of them may get exclusive possession, and ultimately the money, if it is sold, would be split between the individuals. Now, when it comes to the question of the meher, is the meher legally enforceable in Canada? Now, if you recall, in the scenario that we were looking at, they were married in an Islamic ceremony and agreed upon a meher amount of 10,000, with 5,000 to be paid immediately and the remainder deferred. So that 5,000 deferred amount, would it be enforceable? So we have one response, yes. The second, if she signs it, is she stuck? That question is from Najat. Najat, if you could expand on that question. I don't understand it very well, or you can even unmute and just ask the question as well. Small claims court for the meher. That may be a means of pursuing it. The question is that does Canada law recognize meher, this amount that is found normally in Muslim nikah contracts or marriage contracts? So she accepts it at the time of marriage. So if both parties accept it at the time of marriage, then I'm assuming the answer is that it would be enforceable. So we have a few different answers here. It's a little bit complicated. You have to weigh against the lawyer charges. Okay, is it worth it trying to enforce $5,000? Now, the broader question is, what is the meher and what is a nikah contract? So meher, it's forms a part of a domestic contract, essentially, between the husband and the wife, signed at the time of marriage. The wife and the husband agree that upon the signing of this contract, they will be in a marital relationship, and there's a certain consideration given of $10,000 in this case, of which $5,000 to be paid immediately, another $5,000 upon dissolution of marriage, potentially. And if it's in the nikah contract and it follows the rules of contract law in Canada, which is that it is informed consent. Both parties know what they're signing. One would think that it is something that is enforceable in Canada. The reality is that it's a little bit more complicated, and it depends on where you live in Canada. Since different provinces have different rules over what makes a valid domestic contract. A domestic contract could be something like a prenuptial agreement, or even in this case, a nikah contract that talks about meher. different provinces have different rules because these contracts deal with property. In a province like Ontario, a meher contract, if it is signed with informed consent of both parties, they know what they're signing, they can understand it, it's in a language that they understand. I know sometimes these nikah contracts are in Arabic, let's say, and neither party can read Arabic or understand Arabic, and they sign it. The question is, do they know what they're signing? That may be a separate question. But let's say if they are signing a nikah contract, they are able to read it, they know exactly what they're agreeing to. In a province like Ontario, that would be considered a valid domestic contract, and it would be enforceable. Since in the scenario they are living in Ontario, it would be enforceable potentially. But we're living here in Alberta, and Alberta has some different rules. In Alberta, a domestic contract is only legal if it is signed after getting independent legal advice from a lawyer. So the question of whether or not meher is legally enforceable becomes a little bit more complicated. A prenuptial agreement is not valid in Alberta if there is no lawyer who gives independent legal advice in advance. Now, it's a little bit complicated as to whether, let's say, you sign a meher contract in Ontario or a prenuptial agreement in Ontario and then move to Alberta, does it automatically no longer, is it no longer enforceable? And these are issues that are going through the courts right now. Most recently in Alberta, there have been a number of cases that have not found meher to be enforceable. There have been some that have found it to be enforceable as well. But then also, meher has then been subtracted from amounts that would otherwise be awarded as spousal support. So it's become a very complicated issue. In Ontario, it's a little bit cleaner right now. But it will get worked through the courts, and that's how our system works, unfortunately. So hopefully, I end most of my questions with it's complicated, but hopefully behind that, there is a sense that there is a system in place, and it's complicated because there's these competing ideas and these competing priorities within the law, and a judge often has to balance these priorities. So we can move on to, if there's no further questions on that, we can move on to the next question. All right, so inheritance. So we got further information in that scenario that neither Yusuf or Aisha has a will, and Yusuf dies suddenly at work. Aisha knows very little about the family's financial situation. She knows that there's a lot of jewelry in a safe in Yusuf's home office, but doesn't know the combination, doesn't know where they bank, how much money's in their accounts, how much they owe on their house. And Yusuf told her a few years ago when his father died that he inherited several $100,000s, but she does not know where he has, what he has done with that money. In Canada, for our first question, in Canada, what happens when someone dies without a will? So one response is intestate. That word means to die without a will. Yeah. Automatically goes to the spouse is another suggestion. Public trustee is another suggestion. The government administers with respect to given the family interests, and then follows the family law rules. So essentially what happens, the word for dying without a will is intestate. And there is, in fact, a intestate succession act in Alberta, as there is one in Ontario as well, which explains what happens when an individual dies without a will. It's very clean and easy if all you have is one spouse and children from that particular spouse. In the case of dying without a will, all of your property goes to your spouse, essentially. Your spouse still has obligations to your dependent children, and generally within Alberta, it's understood that that the spouse will take care of the children, and all of the property that belongs to the spouse goes to the other spouse upon death. It gets a little bit more complicated now, especially in the case of Yusuf and Aisha, if this second wife exists. And the second wife is brought to Canada, and gets even more complicated if she has children, of course. In that case, the second wife is technically a dependent and has a right to seek support from the estate of Yusuf. Similarly, if the second wife has any children, their children have a right to support from the estate. So in that case, it gets a little bit more complicated. Of course, Aisha has the right to her matrimonial property, which is 50% of the property of the marriage, which is 50% of the matrimonial home, as well as the right to 50% of the property accrued during the marriage. But that other 50% that belongs to Yusuf would have to go towards supporting not only her, but also potentially the second wife and all of Yusuf's children. So it becomes a little bit more complicated in that case. Even if Yusuf died with a will, and let's say he left everything in his will to his second wife, that will could be challenged because Aisha, being the first wife, first of all, already has the right to all her half of the matrimonial property, which wouldn't even be subject to the will, but she also has a right to support from the estate of Yusuf as a dependent, as do her children. So in this case, it just once again becomes a very complicated when the scenario when second common law spouse or something of that nature comes into the picture. Now, one thing with respect to the inherited money, if I'll just note that if Yusuf inherits money during the marriage, or Aisha inherits money during the marriage, if that money is tucked away, or if that property is tucked away and not commingled with the property of the marriage, not commingled with the joint accounts of the marriage or the household, it does remain in Alberta at the very least the sole property of Yusuf's estate, which means that upon a divorce, let's say, Aisha has no right to that inheritance. And vice versa, if Aisha were to inherit something during the marriage and it doesn't get mingled with the property of the marriage, Yusuf has no right to it in terms of any 50-50 split either. I just thought I'd mention that at this moment. So I think I've answered a little bit of the second question as well. Would Yusuf's second wife have a legal right to claim a share of his estate? And I didn't let you respond to that, but I thought it was important to discuss it when we were talking about what happens when you die without a will. So the answer to that would be that yes, Yusuf's second wife would have a legal right to a claim in terms of being a dependent. Of course, she would have to show that she was in fact dependent upon Yusuf. If she was living her own life in Malaysia, not getting any support, then in that case, she wouldn't be considered a dependent. But if in fact a separate household was maintained by Yusuf, prior to his death, in which the second wife was being taken care of. In that case, yes, she would be a dependent and could claim from the estate, even if the will technically did not provide for her, if there was a will. So it does become messy in that scenario. All right. I think we can go to the next slide. So this is continuing on financial questions. If Aisha takes the children and leaves Yusuf, can she get financial assistance from him? Hopefully we can get a few answers, simple yes or no, and then I might call on people to explain their answers if they can. So we have 2 yeses, spousal and child support. Three yeses. So once again, all of you seem to be experts in family law. When it comes to support, it doesn't matter if Aisha leaves Yusuf or Yusuf leaves Aisha. And it doesn't matter the circumstances in which they leave. Ultimately, as I stated before, there's a no-fault divorce regime in Canada. So you don't need a reason to no longer want to live together. Ultimately, if that's what you want going forward, and you do leave and you separate, then in that case, definitely the children can get financial assistance from Yusuf in the form of child support. And that's generally across the board, across Canada, it's very similar. It really depends on how much money Yusuf is making, how much money Aisha is making. In certain circumstances, when it comes to spousal support, and also the idea of who has access and where the children are living. Definitely, if the children are living with Aisha, Yusuf will be obligated to provide support for the children. When it comes to spousal support, in this scenario, it looks like Yusuf is the primary earner in terms of financial work, and it seems like Aisha is taking care of the work at home and the work which is also seen in the context of Canadian law as work, except for the fact that it doesn't give you a financial benefit at the end of the day. And Canadian law looks at this and says, listen, if you've been married for 15, 20 years, Maha's 15 years old now, it seems that Aisha and Yusuf have been married for a long period of time. And during that time, Aisha has contributed to the family in a way that didn't allow her to get ahead in terms of the financial world or the work of employment world, but she contributed to the family nonetheless. And as a result, she's in a disadvantaged position when they separate because she hasn't had the 15, 20 years plus experience in the working world. And the government, the courts look at that and say there needs to be a form of equalization. Because of what Aisha has done for the family for so long, Yusuf now has to support her for a period of time. For a 15 to 20 year marriage, we're talking about support that can last a very, very long time to somewhat equalize the imbalance that was created by the way in which they chose to portion out the obligations within the marriage. And take on different responsibilities in the marriage. So both Aisha and the children will be entitled to support. Doesn't matter, the fact that she left him doesn't matter. And of course, this is an important question because in many Muslim legal frameworks, there is a difference depending on who leaves whom or who wishes to get a separation or a divorce or a talaq. And that does not exist within the Canadian legal framework. Does anyone have any questions about that? All right, I guess we can move on to the end of the presentation, but I would want to open it up to some Q&A ultimately. Before I get to that, we've been speaking about the context of Yusuf and Aisha. And the context of Yusuf and Aisha is not unique. And we can go to the next slide. I just wanted to briefly talk about some safety-related matters here. And that it's easy to talk about these things in the abstract, but oftentimes individuals who are in these situations, it's much messier, and there can be forms of abuse, both physical, psychological, and other forms of abuse that can be taking place as well. And ultimately, the Canadian Canadian context has both the family laws, but sometimes the criminal law does have to get involved to provide some protection. And I'm not suggesting that these legal avenues and these legal solutions are the only way in which you can seek help. If any individual that you know is involved in a relationship that has family law or family issues, but those issues go beyond mere issues of making future decisions and go into the realm of violence of any form, then make sure that you seek help from the authorities. You can contact the police. And you can also contact civil society organizations within your region that assist you to navigate through these issues in a way that's both safe and ultimately beneficial for you. So I don't want to suggest that that all of these things can be boiled down to a legal answer of some sort. These are often real issues, and I want to make sure that that's something that's noted as well, and that there are some recourses that you have. Of course, there's the authorities. There are things such as restraining and protection orders as well that might need to be put in place so that these other issues can be then addressed in a safe and productive manner. So we're close to the conclusion, but I just wanted to see maybe Tamizan, if you can see if there's any questions, and we'll go from there.
Oh, and I think there was one other question that just came in, Jamil.
Yeah.
Is cheating the same as polygamy?
All right. So this idea of cheating and my assumption there is that we're talking about an individual who doesn't necessarily get married a second time, but establishes a long-term relationship with another individual while they are married. So this isn't a one-time thing. In the case of it being a one-off occasion, that doesn't create an interdependent relationship. But if, let's say in this case, poor Yusuf, I think he's a caricature for everything that's wrong. But let's say if Yusuf, in addition to this second wife idea, he meets someone and starts a relationship with them while he's married with Aisha, and goes on to form a second home with this individual and create a dependency where he is taking care of certain bills. She is also contributing to the relationship, this third party, this other individual. That essentially is very similar to the circumstance in which Yusuf brings a second wife from Malaysia. The second wife is in a very similar position to an individual who Yusuf could just meet and create a relationship with as well. The question in law is this in fact an adult interdependent relationship? And if it is, then there are certain rights that a partner within that relationship has to things such as support and even property, if that property is seen as a joint venture. And that seems very callous when we're talking about people with emotions, but a joint venture essentially is like going into business together. And if this individual that Yusuf is cheating with, if both of them in fact do set up a life together in a certain way, then the fruits of that life are seen somewhat as a joint venture. And therefore, the spouse, in this case, the person who Yusuf is cheating on Aisha with, does have certain rights over the fruits of that venture. So.
Jamil, thank you very much for presenting and providing such a thoughtful discussion of this information. I think that today you really have helped us provide that overview and of this information, and I feel like the cases actually were really well managed. So thank you very much. We really do appreciate it.
I was happy to have the opportunity. Thank you.
So as everyone knows, there was sort of that pre-workshop material that we spoke about, the primer that had been available. Today was really the overview of the Muslim and Canadian family law and facilitated discussion on that law through the use of scenarios that covered those 6 key areas. And so our next step moving forward would be to explore specific family law issues in some detail. And so that's sort of where CCMW is sort of seeing this moving forward.
I have a suggestion. Can Nuzat say thank you, please? Do you want to say some thank you words, Nuzat?
Sure, I would be happy to say thank you. So, Jamil, thank you for an excellent workshop. You got it all well organized and followed the scenario and did a great job in making it interactive. So thank you very much. And also thank you, Tamizan, for facilitating the session. We really appreciate it. I'm so proud of the work that the chapters are doing, and Edmonton came through with flying colors to deliver this. So thank you very much. Wonderful job, and stay tuned for more, because we will keep on doing these things, and hopefully we will engage with you in the future. Thank you again.
Well, on that lovely note, I'd like to move forward to say that evaluations will be emailed off to everybody that has attended. And we thank you in advance for completing those evaluations. It'll really help us understand the experience that the participants have had as part of this webinar today. And the link for the evaluations will be placed in the chat box today, but also will be emailed later on to you today as well. So thank you very much for participating. And thank you again, Jamil. I think that brings us to the end. So unless there are any further